and we're going to get started, y'all. I believe this is about fifth in our winter series with the Small Business Center Network. So grateful to our partners at Southwestern Community College, Haywood Community College, and Tri-County Community College. We work very closely with our small business centers and are very grateful for their partnership in this series. This series is directed by Empowering Mountain Food Systems, which is an initiative of the Center for Environmental Farming Systems. We received funding from the Appalachian Regional Commission, the Cherokee Preservation Foundation, and North Carolina Cooperative Extension. Tonight, we're going to talk about liability for on-farm visits. It's something that most folks don't want to think about, but it's the first thing you should think about when you think about having folks come to your farm. We want to help you protect all those things that you've been working so hard on. We're very grateful to have professor and attorney Robert Andrew Brannon with us. Andrew teaches at NC State University, and he has been practicing for many years, working with farmers, and has a very special affinity for Western North Carolina. And now that things are easing up, we're really looking forward to have him come out and see folks. We do want to offer a land recognition that this project is based in the Eastern Band of Cherokee Indians. We're very grateful for the Cooperative Extension Office of the Eastern Band for hosting this project. And we recognize our role as visitor and friend, and again, are very grateful for this hosting. We want everybody to be aware of the programs of Empowering Mountain Food Systems. We do provide services like this to anybody, but our grants, loans, business counseling, and our farmer collaborative newsletter and farmer collaborative, those things are only open to folks who are working with in the 7 southwestern North Carolina counties. If you are in those counties and you haven't yet contacted us, I encourage you to go to this website that's shown here, hit the Apply Now button, and get to know us and how we can collaborate together. We do have a workshop coming up. I believe we're skipping a week, and our next one is March 10th. And I'm really excited to have KT of KT's Orchard with us to talk about value-added processing and farm safety. So with that, I'm going to stop my share, and Andrew is going to start his.
All right. Hey, everybody. I'm going to do my little trick here that's a bit of self-promotion, but I do it to kind of show everybody I'm out of compliance there. If you work for NC State, you get those every once in a while. The web portal that I manage for cooperative extension, the extension IT people were kind enough to set me up one, and so it's sort of the place where I hang all my work, so to speak, for extension, all my writings about various topics related to land and operational legal issues and things like that. And so it's farm law, and I mean the easiest way to get it is farm law NCSU, and it of course pops up, but I think the SEO is pretty good, and if you just type that in, you'll find it. And so this is it, and so you'll see here that I try to on a weekly basis, but more bi-weekly, try to post up some form of news item. But I've organized it here where, if you're dealing with estate planning issues, leasing issues, things like that, there's like templates and things in this tab. For just regular land use issues like property taxes and other things, conservation issues, zoning, you can find various materials, narratives and presentations there. And for us tonight, I put this under the agribusiness law bucket because we're talking about liability for on-farm. And so I put it under this tab. And you can see I've got a couple of articles here. This is a new fact sheet that I wrote for Cooperative Extension. I just want to draw y'all's attention to it so you can read it on your own time. But it's basically, it outlines what I'm talking about this evening. just about, what negligence is, the statutory defenses, all of that. But I'm not going to read that. I'm going to go to the PowerPoint that I prepared on the topic, which is going to be this one here. I'm going to probably open this one. I saw one of y'all has an LLC set up, so that's cool. But I'll open this one up next and do a couple of slides from that also. And if it's okay with y'all, since we're looking at the computer screen, I'll probably just leave it like this. Since we've started doing live presentations again, like out in-person presentations with Cooperative Extension, I've still put up slides that have really small print because for 2 years, everybody's just been looking at the computer screen. So I'm trying to get out of that but for our purposes tonight, I think it'll be okay. So the disclaimer that I put on here, and this is one that I had in the presentation on zoning and building permits, because there are some, and it's not our topic tonight, but there are some statutory exemptions for getting building permits and things like that if your farm structures are on a bona fide farm and are going to be used in agritourism. But it's just an admonition to folks that, don't make that kind of decision without finding out from your local zoning authority what you can and can't do. I said this last night at a meeting, I said this morning at a meeting, better to ask forgiveness than seek permission is not really a thing in law. Once you've done something that's outside of a regulation, you've got to, tear it down and get back in. But my point is that I'm not giving legal advice in this. I am a licensed attorney. My identity now is that of really a college professor and extension professional that has experience in law. And the thing is, the topic that I'm talking about tonight is I'm going to outline it, but there's so much about it we don't know because we don't have a lot of case law on what's happened when people get injured on the farm and whether these liability limitation statutes work. We just found out that we have another liability limitation statute related to farming that is called the right to farm law, and it deals with farm nuisance. That is your neighbor complaining that they don't like the smell or the noise, and so they sue you to make you stop. Well, generally you're protected under state law from that type of lawsuit. Well, there were all these lawsuits against hog farmers down east over the past couple of years, and the judge just sort of swept aside the right to farm law and let those cases go to jury verdicts. And so, my point is that if something were to happen and it gets so far as to be in a courtroom in front of a jury, you never know really what's going to happen. And I'll talk about insurance in a little while, or I'll do that in that next presentation. But but generally, that's going to be standing in your way, or between you and whoever comes to your farm and gets injured. But I'll talk about that. So just know that these are just general concepts on negligence and the liability limitation statutes. Just want to make sure there's no big question. Okay. Let me move that. So here's what this is all about. When someone's injured on your farm, it's not strict liability. I put here the injured person might think so. They might get hurt, and then they turn to you and go, okay, what are you going to do about this? How are you going to make this right? Well, just because somebody's been injured doesn't mean that you're responsible for it. And so they might think that you are, but they have a pretty steep hill to climb to prove that you're responsible. And the legal concept of responsibility is called negligence, meaning basically that you failed in a duty that you owed to the person visiting your farm to act as a reasonable and prudent person would. And that term, reasonable and prudent person, think of any type of setting, and that, like, think of a surgeon, think of a lawyer, think of an accountant, think of you as an agritourism operator. It's different standards that attach to whatever it is you happen to be doing. And so when we think of reasonable and prudent person in in an agritourism setting, we're thinking about, someone who's keeping their farm safe, who's warning people against, dangerous things, dangerous animals, things like that. So, but that question of reasonability is always going to be in the eyes of the jury based on the evidence, the facts surrounding the situation as it unfolded. And so, so I listed here, basically with the 4 elements that a plaintiff must prove to attach liability to you for an injury that happens on the farm. A, did you owe a duty to the person there? Well, if they were invited to the farm, you do. If they're a trespasser, and I'll point this out later, if they're a trespasser under state statute and common law, you owe them no duty, with some minor exceptions or some very narrow exceptions. But generally, you owe a duty to warn people of dangers, to not have a dangerous operation, things like that. The second question is, did you breach that duty? And so that's just, did you fail to warn of very dangerous things, of a dangerous animal, or allow somebody to come into proximity to an animal that had a history of irrational behavior or whatnot? Somebody fell in a ditch that was left available to them to wander over to and fall in, whatever it happens to be. Did that breach cause their injury? That's something they have to prove, and then they have to prove the extent of their damages. So it's not as if that they get hurt and then they're just like, well, pay me $500,000. Well, they've got to prove that their damages are $500,000. There's a concept in law called make the plaintiff whole, WHOLE, and that is, think of a pie chart. That your negligence has taken a slice out of the pie of their life. Well, your liability is compensating and filling in that pie slice back in. So, but that's basic negligence. And these are the standards under North Carolina law regarding people that visit your farm. And again, now, and this was back in 1998, this case here that I've highlighted, I teach it in my agricultural law course. There used to be 3 classes of people that come onto your farm. Now there's just 2. Either they're invited or they're there without your knowledge, and that they're trespassers. And so for somebody that you invite, which we call an invitee, these are your duties. A landowner, and if you're leasing land as an operator from somebody else, then you're, as the lessee, stepping into the shoes of the landowner in terms of management of that land. So, but a landowner owes a duty to exercise reasonable care in the maintenance of his or her or their premises for the protection of lawful visitors. Lawful meaning they're not trespassing. Reasonable care requires that a landowner not unnecessarily expose a lawful visitor to dangers and must give warning of hidden hazards of which the landowner has expressed or implied knowledge. Now, there's a lot to unpack there, because the whole concept of just landowner liability when you're inviting people on your land to recreate, whether it's ATVs or hunt or hike or whatever, implied in law is that you need to have some knowledge of what you got there. And I always sort of look this, there's a reasonable duty on landowners to reasonably inspect their property. But if you know about something in an agritourism operation, we're talking about a limited, footprint that you're going to allow people into. And so what that's saying there is that, if there's something there like an uncapped well or a ditch without a fence on it, or and just start thinking of things that can hurt people, that you have a duty to make sure that they're aware of it. You do not have a duty. And Nelson v. Freeland, the Supreme Court of North Carolina, made this very clear. You're not an insurer of your property, of visitors' safety. You just have a duty to warn them, because, and as I'll get to in the couple slides here, they've got to use their good judgment too, not to hurt themselves. And that does come into play. Here I have trespassers are owed no duty except unless you willfully hurt them or you act so wantonly towards their safety that that the trespasser is injured. The warning I always give to landowners is, if you're upset about ATV trespass, don't just put like a wire across the the path entrance to the woods or wherever, because a plaintiff's lawyer could easily say, well, they put that there to teach them a lesson, teach the trespassers a lesson. I always tell folks, either buy gates or clearly with tape, mark chains and be warning people against coming in. So, but there are defenses to negligence, and I'm putting these up here pre-liability defense statute, which I'll go through those. But the main one, and this is in North Carolina, there's the concept of contributory negligence exists everywhere. It's just that North Carolina is a strict contributory negligence state. And that is if you can show as the defendant, and we're going to assume that things have gone so far that you're in court, that if you can show that the plaintiff, the person that was hurt, contributed to their own injury, they failed to appreciate an obvious danger, or they failed to heed your warning signs or something like that, they showed up drunk, whatever it happens to be. In North Carolina, just 1 ounce of that will throw out the claim. In other states, they follow a comparative negligence, meaning that they can prove that you're 80% negligent, they were 20% negligent, you're responsible for 80% of their damages. Not so in North Carolina. We're just a straight contributory negligence state. And I put a couple of questions here, that generally parents are responsible for their children. But this one raises a question here, what do you do when you have an obviously impaired visitor to your farm? And I don't know the answer to that. There might be some case law on it, and I just recently came up with that question. But it factors in to those who operate equine operations, that there is a duty on their part to make some assessment of people's ability to do the activities on the farm. One of those is, can you ride a horse? Well, what I would say to somebody is that if there's somebody that's visibly impaired on your property, not a handicapped person or somebody with special needs, just remove them, because they become somewhat of a liability for an injury. They could argue, even though contributory negligence might throw this thing out, they might argue it's like, look, I was obviously impaired and they just let me continue on with what I was doing. And so, like I said, I don't know how that plays out, but that popped into my head and I thought I'd put it here. So another defense of your negligence as the landowner / operator is in common law is called assumption of the risk. And so this takes us into the basic theory behind our agritourism, equine, and livestock activity liability limitation statutes under Title 99 or Chapter 99E of the North Carolina General Statutes. The theory is the customer knows what they're getting into. And if we're going to a equine farm for horse riding lessons or trail riding or something like that, there's a statute for that. If we're going to a rodeo or some sort of livestock demonstration or sale on a farm, there's a statute for that. And they added one, I say the General Assembly added one in the mid-aughts. I want to say it was like 2006 or so, that dealt specifically with agritourism, as that term was becoming more accepted as a legitimate income earning activity that happens on a farm. And so they created another statute for that. They're all slightly different, but they all operate around this same assumption of the risk principle. And as I will emphasize several times, and I make an assumption that folks already know this, but one of the requirements of these statutes is you put signage up, 2 signs with language. And to me, that's the same thing as handing them a liability waiver for them to sign. It's saying, look, you're coming onto a farm, there are things that go on here. And so you're assuming the risk of coming onto the farm. I want to say at the outset, the liability statute does not insulate you from negligence. That's always going to be there. What these laws did essentially is it provided a court with a way to keep the jury from hearing the details of what was going on that farm if it was just normal farm activities. If you didn't have this statute, then things could proceed to through trial to a jury. And once it gets to a jury, you never know what's going to happen. But again, these statutes are largely untested in North Carolina. I'm not aware of any cases dealing specifically with what are inherent risks on a farm or in an equine operation, but the statutes give us some illustration, and I'll talk about those. So first and foremost, before I jump into those, just protecting your business and assets. So I always do a thing about the difference between liability and regulation, because people will always ask, am I liable if I violate this regulation? Well, that's not really how to phrase it. Liability is what I'm talking about here, this common law negligence. It's once these four elements are proved, then liability attaches to you as the manager of that particular activity that injured somebody. So the first line of defense, of course, is operate in a safe manner, and went through those with the invitees and trespassers and all that. But then, of course, there's insurance. I'll pop in some insurance slides here a little later, but the role of insurance, and I would say this is, no one gets to set foot on your farm without you having a farm liability policy, and more specifically, a farm liability policy that has a rider on it and a premium, the adjusted premium for this liability, so the insurer knows what you're doing. Don't jump from you're raising livestock or selling crops at the farmer's market. Don't jump from that to inviting people onto your farm without talking to your insurance company and getting extra insurance for that, because what your insurance company doesn't know, that's not part of the deal. It's not part of your premium. They're setting the premium at their risk at their assessment of the risk that you're taking on their behalf. So but insurance, of course, it would pay for the damages. But the big thing, once someone's injured, it's going to pay for your defense. And that is, when this happens, you need to call the insurance. When something happens, you need to call the insurance company immediately and within a reasonable time, and let them know. I was in a program this morning over in Warren County, and there was an Farm Bureau insurance guy up there, and he was like, yeah, he was telling a story about somebody called in a year later. Well, it's, your contract probably says within a reasonable time, and it's been determined somewhere that what that time period is.
So Andrew,
yeah.
We did get a question. Francis, if you can unmute. I don't know if you can unmute yourself. There you go. Francis, can you ask your question about your insurance?
It seems like I have possibly the wrong type of policy. We explained to our local Cherokee County Farm Bureau agency that we wanted a farm rider policy. And we tried adding, our typical homeowners insurance is with Nationwide Insurance, and we tried adding a farm rider policy to it, but it does not cover what we thought it would. And
Right.
That's why we set up a whole farm insurance policy with Farm Bureau.
Right. And
it
those
does seem like it still covers the farm liability.
Right. And so a whole farm liability policy, it's just going to depend. Lisa G, I'll answer that. Is that you, Lisa Gonzalez? What Farm Bureau, the farm policy is that they are insuring for injuries that occur on the farm. But whatever the term, where they call it whole, WHOL farm policy or whatever, it all depends on what the policy says. There's not like a standard, description of a policy that you'll know by its title covers all these things. You've just got to read what's in the policy and specifically what it covers. Now, for most generic, what I call the generic farm policy from Farm Bureau, that's going to cover you for people that just happen to come on your farm and get injured or whatnot. But if you're running an active operation and inviting people there and charging them, that's a whole different thing. Oh, thank you. Sorry. And so when you want to make sure that that Farm Bureau or whoever the insurance agency is aware of the activities, the specific activities that you're doing, or they've added into the contract enough descriptive language to cover it. And normally, if you just have a generic farm policy, they'll add what's known as a rider, and that's the RIDER. It's think of it as something that's writing on your policy. Basically, it's an appendix to the policy. They don't write you a whole new policy, but they're going to add a rider to it that's going to be descriptive more of what your expanded activity is. And the more things you do, the more premium you pay, because the more risk you're taking on.
Okay, I know we have a lot to cover. One of the things I want to recommend is that if you are having visitors on your farm, is to become a member of the NC-ANA, the Agritourism Network and I'll paste that link in there, because they have a lot of resources about farm insurance that they have already addressed. And so I don't want Andrew to get too much more into that. So I can paste that resource in there and you can keep going.
I was
Okay,
going to
thank
say
you.
that may answer my question, because my whole policy is set up for Cherokee County, and we are right on the border of Clay County. It just seemed like the whole policy was wrong.
They should be able to fix that for you.
Okay.
Let's talk about that at the very end. So, and Lisa G, that's what a farm rider is, or a policy rider is. And I'll talk in a little while about business entity setup, but the quick thing I'll say about regulations, and this is not so much in the well, it does relate to agritourism, because agritourism is not really a heavily regulated business. It could certainly be something there where you're violating a zoning regulation, or you didn't get the right permit for something you've done to a barn that you've refitted and something like that. And if you're found in violation of an actual regulation and somebody's injured because of that, that changes the burden of proof, and you are in a tougher place. So when I talk about zoning and stuff like that, I'm just like, just know, you have all your permits for everything you build, and know what you have to have permits for and all that kind of thing. So the statutes themselves, I just posted, this is my introduction. I just posted the 3 distinct signs, but the signage becomes very, very, very important, because without posting the signage, you don't get protection of the statute. The statute's pretty clear on that, and the cases I've read from similar statutes around the country, same thing. If you can't show evidence, when your lawyer would bring this up in a pretrial motion, that, hey, we're filing a motion to dismiss because we're protected under chapter 99E, the plaintiff's going to say, well, I didn't see a warning sign, and the judge might turn to you and say, yeah, can you show some evidence of the warning sign? And if you're like, I've got nothing, judge really has no choice at that point to let things proceed forward. So you want to have the signage up and be able to prove it to a judge that that you had that signage. So this slide might be out of order, but what these statutes protect against are inherent risks. And again, it's a question for the jury. Ultimately, if and we just don't know how this goes down in court, because we don't have any cases that have described it. But I think of these things as, what's an inherent risk? Is getting salmonella an inherent risk? Falling off a hayride, falling in a ditch, getting gored by a bull, kicked by a donkey, who knows? I would argue that a lot of these are, yes, inherent risks, but a lot of these you can see here are things that would be dangers that you would just want to keep customers away from in the first place. Again, these, the term inherent risk is very generically defined in the statute. Oh, I want to make sure I have the right one. I'm going to go ahead. I'll go ahead and jump this injury by animals on farm and move that to later. But this is just an example. This is 99E6. Like I said, there's three of the statutes, and I'll show you real quick just how they're laid out. And again, the first one was the equine statute. And that is because that was the first industry that stepped forward and said, hey, you know what, we need some liability protection. It's public policy that we have a horse industry here. And so, we start out with this one here. That's the equine. Well, later on, some folks said, hey, we do rodeos and draft animal demonstrations and stuff. And so they had this farm animal activity liability policy. Statute. Roller skating rinks get one. And then hazardous recreation parks get one. And then down to whatever year this was, 2005. Yeah. Agritourism liability. And so this is generally the one we're talking about, but those other ones, particularly, you never know which one might come into play. It just depends on your operation. So jumping back to the, and I'll point out some language in these, which I've copied into some of the slides, but so in the livestock and equine statutes, there is a definition of inherent risk. And this is one, a possibility of farm animal behaving in ways that may result in injury, all that. That's still going to be subject to certain common law requirements, which I'll show here in a little bit. People should realize that animals are, that they act in unpredictable ways. And in a sense, we know that horses have limited vision. We know various animals have limited vision, and they're going to react to something that they see move out of their vision, either by jumping or kicking or something like that, or they're easily also startled. I mean, they're prey animals. They're not predators, and so they respond to stimuli rather than they're the thing that's being hunted. So that's just in their makeup. Well, also the risk of illness. Inherent risks of farm activity does not include a collision or accident involving a motor vehicle. Just want to make, they add that into the statute that that's something that's not an inherent risk. With all of these, and I'll do this here first. This is the 99E, the agritourism one. You see here this list, which sort of builds on these earlier ones, the equine and the livestock, but you see here, these are the inherent risks are surface and subsurface conditions, natural conditions of land, vegetation and waters, the behavior of wild or domestic animals, and ordinary dangers of structures or equipment ordinarily used in farming and ranching operations. And so you see here that what the legislature is trying to do is warn your customers that these are things that are there on the farm. Now, of course, remember the first line of defense against liability is to operate safely. So you just don't want to have sharp equipment that's exposed to people, allow people in near the equipment shed, things like that, and be very aware of the animals that you have and what their propensities are. But also say that natural conditions of land is an uncapped well that you might be aware of. A natural condition, maybe not. Is a ditch a natural condition? Again, these terms, this descriptive language that the legislature wrote has not been tested that we know of. I mean, it's just not there. There's no case yet that compares the actual facts of what happened to this language there. So, but again, ultimately, it's the the judge is going to be deciding these matters about whether to allow this statute to protect a case from going forward. But it's not without limitation. And here's an example from the equine statute. These are the exceptions, so to speak, that yep, you have liability protection, but if you provide faulty tack, or you should have known that the tack was faulty, and I mentioned this earlier, you as the operator failed to make a reasonable and prudent effort to determine the ability of the participant to engage in the activity. If that's shown, if evidence of that is shown, then the statute doesn't protect. The exceptions in the agritourism, and I bolded this one, has actual knowledge or reasonably should have known of an existing dangerous condition on the land, facilities, or equipment used in the activity, or the dangerous propensity of a particular animal used in such activity, and you don't make that danger known to the participant. So that's considered an exception to the protection you would get. And again, this is the thing that a plaintiff, an injured person, would try to bring forward about your operation. It's like, look, they had a hay rake that was really sharp that was just in the equipment shed, and people were walking by it and things like that. That could, if that were said, that could be, and they got cut on it. That could be something that said that was something that you should have known was a dangerous condition. So again, these are all facts. This is just, I'm really just explaining how these statutes generally operate to protect you. Here's the biggie though. Again, signage is required. This is right out of the statute. It says that you must post 2 of them. And my suggestion is, I mean, this is the language that is used. And if you kind of see the theory, it's basically telling the person before they come onto your land, go look up the statute and read it and read what inherent risks are. And so, but again, the signage in theory, legally, is what invokes the coverage of the statute. And my suggestion to folks is to have one of these at the gate, or the entry where people come in, and have one at the intake, where the cash is coming in. You can't have, you're not limited to 2, of course. It certainly wouldn't hurt to have more, but I think this is just at a minimum, you must have 2 signs to be able to invoke the statute for protection. I tell livestock people that just have cows and don't have a gate on their driveway to have one of these on their fence post anyways, because people will come by soliciting whatever. Generally, if you don't have your gate locked or whatnot, you might, if you don't have a no trespassing sign or private property do not enter, that's not there. People are going to feel like they have implied permission, and the law might look at it like they have implied permission to be on your property, and suddenly they're in that invitee category. This is just a summary of everything that I've just said. Here's just a little bit of the liability standards at common law. Again, I'm being a little bit academic here, but this is stuff that's in that paper, and this is telling you more about the animals that are on the farm, and to be careful. But if the animal has been deemed vicious, and this sort of goes to we have statutes dealing with dogs, not with farm animals, but we generally follow this 1 bite rule, and I'm sure y'all have all heard of that. That once something like that happens, you're on notice. Now, if some person gets behind a donkey or a horse or something to get kicked, that doesn't mean that's not going to classify the animal as vicious. That's just going to be something that it's that any animal like that would do. But just know that if somebody could bring into court the animal's prior behavior, whatever that might be, it might be that somebody had had shot a video of it or something, and things had happened before, and they were able to bring out that information. And that's one of the things about litigation, is there's not really much you can hide, is in terms of evidence that the plaintiff doesn't have. The plaintiff has to have enough evidence to get into court, but they don't have all the evidence to prove their case. And that's why we have this thing in litigation called discovery. And what discovery is, it's basically the parties are trading questionnaires, and asking for documents, and it requests people to admit, has anybody ever been injured by this horse before? Yes or no. Has this goat ever bitten someone before? Yes or no. Have you ever had a complaint or has an injury occurred on your farm? Yes or no. And you answer things like yes, then they're going deeper into looking for information. Like, well, who was that? And so, like I said, there's in litigation parties, there's not much that people can hide because you're required by the court and under the rules of evidence to comply with these lawful discovery requests. So, but for animals, injuries by animals, the evidence will out, so to speak. Once something happens, the plaintiff will start making inquiries about previous injuries on your farm and previous, particularly of animals. Liability waivers, not required by 99E. We know from case law in North Carolina that they do work. Again, this is every operator's personal choice, whether they have somebody fill something out when they hand over the cash for the activity or they come onto the farm. It's really just your call. We do, like I said, we know from some appeals court cases that liability waivers do work. Do they immunize you from negligence? No, I don't, not necessarily. Again, this is all about just the inherent risks. And there with the inherent risk, if there's a danger that you're aware of, you have a duty to warn. So I guess if we could sum up this whole long presentation, duty to warn is baked into all of this. If there's something that you know or should know is going to be a danger to people. So let me go into that here. So my advice education here is post your signage. Make sure you have those signage, and you can get those from, and I saw that Laura put in the ANA website. I think they sell them for a very nominal cost, but you can get those signs, you can order them. Of course, operating a safe manner, warnings of or just blocking off. My advice is just to block off dangerous areas. Be very aware of where people are going to be on the farm. I put fence repairs in there because there might be internal fencing that's that an animal might escape from and injure somebody. Well, people are going to ask at that point, well, how often do you fix that fence? That's particularly relevant when livestock escapes and gets out on the highway and people run into it and are injured. That's one of the first questions is how often do you fix this fence? Or how good is this fence? Things like that. And I picked this up actually in a recent legal education course on equine litigation. And I thought it was pretty good. And that is getting out your phone. I don't have mine handy, but getting out your phone and just making some video files of your animals, maybe of interacting with people, with somebody. For equine, the suggestion of this lawyer that was doing this presentation was do a quick video shoot of just somebody riding this particular horse to show some evidence that it's just not a crazy wild animal. Because that's of course what injured plaintiff is going to say, that hey, this person's keeping dangerous animals. Well, this is counter evidence of that. And I said this to an audience last night. It was at a cattlemen's meeting that people get annoyed when people like me say document, because it's stuff you got to do. It's just good risk management. And it's particularly really good litigation risk management. You just document it and file it away for that rainy day. When that rainy day comes, then you're going to have it, and it'll really, I feel like it, really prove its value in getting rid of an uncomfortable situation that you're in. Laura, how long are we, or anybody, I'll jump to this other presentation just to talk a little bit more about insurance and a brief overview of business entities. Laura, how long do we go to?
Till 7, and we don't have any questions in the chat so far. So here's your chance, y'all. We have about 10 more minutes. I know we can go over a little bit, but if you do have a burning question, go ahead and put it in the chat. Thanks.
Yeah, hit me with them. Okay, well, until one of those comes in, but I'll react to it when it does. But not that one, this one. Not this one. let me go back to the farm law and pull up the other presentation that I drawn your attention to. This is just, folks always ask, I throw the word LLC, limited liability company, around a lot and not really, bothering to explain a lot of times, but I'll just do a quick demo, so to speak, of what I'm talking about there. So this is a presentation that's just 7 slides. That was part of a larger one that I broke out, but it's covering just the basics of insurance. And I've said everything that's on this slide right here already. Again, a premises liability policy, your standard Farm Bureau policy, probably not sufficient. Unless it's got that rider on there that is spelling out, basically acknowledging the insurance company's knowledge of what it is you're doing, what your operation is, and how you're coming into contact with members of the public. I know earlier, one of you mentioned the homeowner's policy. Just don't, I've always recommend people not try to insure, do liability insurance on a farm, even one that does not invite people onto the property, with a homeowner's policy. It's just that the insurance companies are not, they're not going to be as attuned to agricultural risk. And I would say this, and I'm only saying this anecdotally, but it was said last night in a meeting, that they will bolt after that claim is made. They might cover it, but you'll have to go shopping for new insurance. The insurance company that's been mentioned here was the one that was brought up by this farmer that has stuck around even after a claim was made and paid for a livestock injury off the farm. That person is still insured by that same insurance company. But again, insurance, it'll pay the claim, the injury claim, and more importantly, it pays for your litigation. But once an injury occurs, somebody comes to you and they want you to the first and foremost thing is just notify your insurance company. And if someone, and get the name of whoever the person who is injured is supposed to contact, because really the insurance company at that point wants you out of the equation. They don't want you talking to the person who is injured, because you might say something like, yeah, I really shouldn't have left that there. Or, yeah, God, I've known about that thing for years and I was going to do something and I didn't. You've done, that's, the insurance company does not want you talking to the person that was injured. And so that, they'll take it from there, so to speak. But again, once somebody sets, inviting people on your farm, you want to make sure that you've got that in your contract. Use of business entities, if I can, real quick. This can be somewhat helpful. I noticed earlier somebody had posted that they're new farmer, but they're already organized as an LLC. Good. I think it's a good, it doesn't come without cost, in the sense that you do have to pay an annual fee of $200 to the Secretary of State. But this does have the effect, the legal effect, of separating out your business assets, those that you use to operate and earn income, from your personal assets. And I consider land to be a personal asset, not just your house, but your entire farm. The farm should always remain in your name. It should not be deeded into an entity that you're operating as a farm. And so, for example, you have an agritourism operation. Let's keep it so you're inviting people, you're growing strawberries and people are coming to pick strawberries. Well, all your inputs, all your labor, everything you're putting into growing those strawberries and managing the people coming onto the farm, the labor, all of that could belong in the operating LLC. It's all coming out of that checking account, everything that's being paid for, but you lease the land that you're operating on, that's your land, from yourself. Sounds, I know, kind of weird, but it's not. This is how the structure works. And the key is that you're keeping things absolutely separate. You're writing yourself a check every year in rent, and you're reporting that check on your taxes. It's just an above the board payment. You write a check out of your operating account, your QuickBooks account, whatever it is, to yourself personally. And you then put that in, cash that or deposit in your personal checking account. And so the lease though, and I have examples of this on the farm law website in the farm succession tab. You set up as a triple net lease. And so it obligates the operating LLC, the tenant, to pay the property taxes, pay the farm policy insurance, and of course, do the rent check. Let's see, but your home primary residence property has a law defined you're liable for incident as an I would say this. Think about your question. For what Amanda, I think what I'm reading there is that that maybe it's somebody that is. Oh, I see what you're saying. When does liability attach to you individually? Sorry. So that's somewhat of a challenging question when you're the single member LLC, meaning it's just you, it's not two people. I think it still provides liability protection. There's an argument that if you're the only person doing everything, meaning you don't have any employees, you do every single thing, and you did the deed that caused the injury, then there's a theory that you could be held personally liable in addition to the LLC, but I have not seen that. It's called piercing the corporate veil. The surest track to someone attaching liability to you individually is if they're able to show that you paid personal expenses out of your operating account. You did you basically ran your life or paid for your life inside of the out of the operating LLC. And I know that gets a little bit tricky when we have our house that we live in on the farm that we're operating, and we have a loan. Who's paying for that loan? Well, in theory, you should be distributing enough money to yourself from your operating LLC to make your loan payments and things like that. But the concept of LLC versus individual liability is so long, I believe, that you're able to demonstrate that the only thing that's coming out of that operating LLC are legitimate business expenses, not just paying for all of your gas for personal errands and all of your personal needs. You should be okay, I think. So I'll do this real quick and then I think we'll probably be done. I do this here. Normally when you do an LLC, for a very small farm, it might just be you. Sometimes it might be you and a spouse. If it's you and a non-marital partner, it's very advisable to have an operating agreement, because what that is, it's the contract between you and your partner. Y'all are called members as owners of the LLC, but this is just terminology that the law is assigned to these different entities. But LLCs can be used in a number of different manners. In my practice, I would use them a lot for land succession. If a family owned land that they wanted to create a lineal line of would-be owners of that land, they could put it in an LLC and restrict who could be a member. It had to be a lineal descendant of so-and-so. And so you can use these in a lot of different contexts, but I think in ours tonight, and I'm talking about liability protection, this is generally what I'm talking about. I do have a piece set up. It's published on the farm law site, just about how you set an LLC up. I'll go ahead and say this. You don't. I don't want to be the person that says nope. You never do anything without going to talk to legal counsel. People set up their own LLCs all the time. It's not a legal requirement that you have a lawyer do it for you. If you are loading in assets with someone else, I would say yes, because you want to have somebody craft that operating agreement, that contract between you and the other individual. But there's a lot of tasks that you're able to do yourself, including the filing, the getting your tax ID, bank account, all that type of things. And so I go into more
Andrew-
detail in this in the piece that's on the farm law site. But
Cool. I've got a question. If
yeah.
if you do hire an attorney, just because you really, just want to be sure about it, what do you think is a normal charge that attorney, I mean, is that a hard question to ask you, but that would charge you to create an LLC? I mean, are we talking thousands of dollars or?
I'll say what I did. I would, for forming an LLC, I would usually do that with a flat fee. I mean, if it was going to be something relatively simple, I'd probably be around the $500 range. And again, what you're doing, I'm sorry.
Right. And pardon me, because that's the easy part. It's not when you're joining in with another partner.
Right. It's when you get into when you're drafting a more advanced operating agreement, and particularly if you're in a land situation and you're doing it with your family in order to create what I call an internal marketplace of interests. That's when the lawyer needs to get more creative and not, it's just a more complicated process in terms of drafting. But the setup, and I'm just using this as an example, and I know this is being recorded, but I generally just do a flat fee of $500. That didn't include the filing fee. Filing fee is $125. If you do it online, Secretary of State charges $2 extra. But that would be for me just doing the whole thing. Going online, doing the filing, preparing a lease for the land if the person owned land. And just doing, a general counseling session on how to set this up. Sometimes I would suggest that if you were farming jointly owned property that tends to buy the entirety property, that's survivorship property that spouses own together, that may not be necessary to make both spouses members in the LLC, because you get an extra layer of protection, because marital property is non-recoverable on the debts of one spouse. You can certainly pay the other spouse to be involved in the operation, pay them a wage and whatnot. But I'd counsel on things like that. And so for doing that with him sitting in the office with me, I'm charging for my time, but it's
okay.
Yeah, that was,
Okay.
I'm sort of fumbling for a good hard and fast answer. And I think I actually quoted a figure. So yeah.
Right. Okay. We're going to wrap up. Does anybody have any questions? We do hope, Andrew and I were on a call this last week, and an invitation was extended for him to come out and do a land summit. So maybe he'll come out here this year after all. And so we will, of course, keep you all posted about that. So thank you so much, Andrew. Appreciate it. I'm so glad you're on campus and working with our ag economists around these issues and continue to be really engaged with extension. We really appreciate it. Thank you. Gosh, you guys, of course, you know what I have to do. I have to post the evaluation.
Laura, can I say just one quick thing?
Yeah.
Please visit the website, and here's my email address. I mean, feel free to email me, or if you go to your extension office, talk to your extension agent. They might do so. But I'll engage with you. I can't give you advice, but I'll be direct. I can direct you to resources and give you some thoughts on things. So.
All right. Well, y'all know how, yes, the recording will be available, and it's especially available to people who fill out the evaluation. So, our funder really likes it. We're hoping to grow and expand this program somehow, and you all letting us know if we're doing a good job, and if we're not, how we can improve it really helps me in my report writing. So I really appreciate that. Please don't leave without that evaluation, but you'll get it. You'll get that link in an email if you don't fill it out. So thank you so much, and thanks. Let's see if we got any questions, or everybody's just saying thank you. Yeah, we will share the recording with you. And great. Well, thank you, Andrew. We appreciate it. And I know we'll see you again on a screen somewhere.
Yep, hopefully in person one of these days. All right, see you, Laura.
Yes.
Bye, everybody.
Okay, take care. Thanks again.